Hello, everybody. I'm Richard Fink. This is the Injured Workers Legal Side podcast with Richard and Paul.
Hello, everyone. My name is Paul Taylor. I'm a paralegal with a specialization in workers' compensation and human rights law. If you want to reach either Richard or myself or be part of our podcast, like our special guest today, you can contact us through the links below. This week's topic, surprisingly, is our special guest, Kendall, and I'm going to butcher his name, McKinney. And he is a retired lawyer. He's one of those special people that I can sense that he didn't become a lawyer for money. He actually became to make change, to make things better for people. I sense that because of what he's doing in his retirement. He retired in 2019 and he's been doing oodles of advocacy work, the list is too long. He's going to have to tell you. But I do know that he works with injured workers and helping them. One big project he's working on right now, he calls it the Meredith Act. I think it should be called the Kendall Act because of all the work he's done into it. And it's rewriting the Workers' Compensation Act. So take it away, Kendall.
Good morning. I'm Kendall, and yes, I did retire in 2019. I had been working in a general law practice, but had a lot of workers' comp cases, and the stories and their cases were just too much for me to ignore. So, in the course of the practice, I promised after I retired to a couple of them that I would keep up the fight afterwards, and I have. And now I'm active with the Ontario Network of Injured Workers Groups. And yes, the major project that I'm involved in right now is indeed the Meredith Act. We spent over a year drafting up a replacement for the current Workplace Safety and Insurance Act, and we being principally the Ontario Network of Injured Workers Groups, but in consultation with the various workers' compensation clinics and individuals. It was very much a group effort. Trust me, you cannot draft an adequate piece of legislation just out of your own head. You have to talk to people, and it has to be a collaborative effort. That's one of the big lessons that comes out of this. If you want change, you have to work with others to make it happen. We're on the verge now of taking a major step forward in the fight to change the workers' compensation system in Ontario. The member of provincial parliament for Thunder Bay, Superior North, Lise Vaugeois, is a very good advocate and is sponsoring, with the support of Jamie West of Sudbury, what we call the Meredith Act in the Ontario legislature. The Meredith Act would effectively repeal and replace the current Workplace Safety and Insurance Act with a system, a legal system that would be very different and very much more effective and responsive to people's needs with regard to compensation. And yeah, there's a large number of moving parts to this act, which is why it's taken well over a year to get it this far. But we can start, I suppose, by illustrating some of the points. One of the big parts of the current act that is just so dead wrong is that it's modeled very grotesquely after the private insurance model and regards injured workers not so much as beneficiaries of a trust, but as problems to be managed, overcome, and cost contained. And I think that sums up the underlying attitude of both the legislation and the management of workers' comp to date. The Meredith Act, named after Sir William Meredith, who was the original architect of workers' compensation in 1915, would treat injured workers as beneficiaries of a trust. The monies are theirs in trust for their benefit in the event of an injury or illness, occupational related illness, and that of their families, rather than some sort of piggy bank to be rated at the whim of the government. Which gets us to another point is the original conception of these workers' compensation boards right across the country, and indeed all administrative tribunals and boards, is that they're supposed to be independent. Well, it's rather obvious that in the last 30 years, And especially under this government, there's no more independence for these boards. They're being treated exactly as if they were an arm of the executive, like a line ministry. And indeed, the Workers' Safety and Insurance Board website now openly and brazenly announces that it is accountable to the Minister of Labor, which, to legal professionals such as Richard and Paul, is an appalling thought. It's like saying, a judge is accountable to the Minister of Justice. But there it is. They're openly doing that. So one of the things the Meredith Act does is it takes control away from the executive, the premier, the minister, the cabinet, and puts it in the hands of an independent board. And it will truly be independent because it's restricted by qualification. You have to come as a nominee to the board from either business or labor, and it has to come in one of 7 categories of the economy: transportation, manufacturing, construction, agriculture, health services, etc. So the idea is deliberately to restrict the capacity of the premier or anybody else to handpick their little cronies and proteges for appointment to the board, and who will then faithfully carry out the premier's whims, which is what's, of course, been happening right now with the multi-billion-dollar so-called surplus givebacks. So you don't just get at that by restricting the ability to appoint. You also get at that by requiring the appointees to have certain qualifications. We're doing that in this act. Now, to skip ahead a little bit to what happens in October, is that we're trying to generate political pressure so that MPPs will have a real awareness of the fact this act is coming forward as a private member's bill. We've got a lot of work to do before then, both on the technical side of finishing the drafting into legislatively acceptable terms, but also on the political side to create pressure on this. When it comes down to a vote in the House, first off, private members' bills almost always pass on the first reading. That is just simply the motion to accept a bill to debate. Where the crunch comes is on a second reading, which is the motion to send it to committee for committee, detailed examination. That's where they usually either live or die. Now, this is a very, very substantive bill, a lot of moving parts. It has a lot of effects. And I'll go back to that in a minute. But at that point, there was probably going to be a move by the government to shoot it down. If they do that, and we're accepting that as a probability, not a certainty, what will then happen is a vote that we will know exactly where every MPP in the legislature stands on workers' compensation. We'll know them by name, we'll know them by constituency, and guess what will happen after that if they vote it down? They will be outed publicly. Now, more optimistically, but unlikely, what happens if it passes? Well, if it passes, then we have a completely different workers' compensation regime coming into effect that will be comprehensive, but it will extend not just to the benefit of the injured workers and their families, which will be much, much better because it will deal with most, if not all, of the ills that we've identified under the current act. And I don't have to tell you and Richard what those are. But it will extend beyond that because there's also provisions in the Meredith Act that integrate workers' compensation with health and safety. Because health and safety right now is not integrated to anything. We have workplace health and safety committees out there generating reports and recommendations with utterly no consequence and no feedback. Under this system, the compensable claims will, of course, generate health and safety reports in the workplace, which will be fed back into the compensation system via the new commission, which then has an absolute mandate to integrate and assess all those reports from all those accidents, analyze them, run them along with reports from everything from doctors' reports to coroner's office reports, and send them back out again as recommendations for practice and referrals to the Ministry of Labor for possible prosecution. Aha, true integration of all aspects of the health and safety system.
So when you say prosecution, one of the big concerns on the labor side, especially from the steel workers, this is their motto is kill a worker, go to jail.
Hmm.
And that currently there is no criminal prosecution in Canada.
Yeah.
Is that with the West Ray Mine Act, businesses, and actually I was surprised to learn even government, the Ministry of Labor was actually charged under the criminal code. It was a case up in Sudbury with a miner, but the Crown prosecutor swooped in and stayed the charges. But at any rate, so would that be like, because like I remember having about a year or two ago a seminar on workers' compensation. One of the big issues with all the lawyers and paralegals, the Crown, it was fascinating because both the Crown prosecutor for provincial, which would cover OSHA, Occupational Health and Safety Act, and the criminal code were present. And the one for the criminal code said that they will be working, well, this is what they said, is that they'll be working closely together and bringing more criminal prosecutions.
Yeah.
Now, I understand the standard of criminal is very, very high and very, very difficult. But it seems like to me in many ways is they default to the easy way, which I mean, I don't blame them in many ways, but like in my understanding of criminal law, and I'm not a prosecutor, I've never been a prosecutor. I have defended people in criminal court. But oftentimes the Crown, as you know, will say assault with a deadly weapon, uttering a death threat, blah, blah, blah. In other words, what I'm saying is that they throw all the charges at them. Am I wrong in saying that? Is it not wrong for them to say, okay, employer Mr. Richard Fink, he's not, but I'm just saying, we're going to
Emma,
charge.
how are you feeling? Are you injured right now?
Yeah, really. Are you you're going to be charged under the criminal code for workplace fatality and also under OSHA. So that way, if the criminal one falls apart, you can default to the OSHA. I think there might be some issue with why they're not doing that.
One of the things that happens in practice right now is that the compensation, with its very confused mandate, the WSIA, has its own investigatory and charging branch, which is largely oriented on workers, of course. They also do some investigation and charging of employers for evading their reporting and mostly their premium payments. But one of the things the Meredith Act does is it strips away all the what I call the kangaroo court aspects of the current WSIA system and simply says when in the course of gathering all the information that they have to have, evidence of fraud, whether it be from employers or workers, comes to their attention, or in the case of health and safety violations, they simply refer the matter either to the police or to the Ministry of Labor. So it strips out all the investigatory beyond the first step, and all the prosecutorial aspects of the current system and puts it where it belongs in actually professional hands. Now, it does not address whether the Crown's or the ministry actually pursues itself. That would require a separate matter. And like you, and like the steel workers, I think the politically influenced lack of diligence in going after negligence on the part of employers is a problem, but it's a problem that we just have to accept cannot be got at through the compensation system. And what we are doing, though, is we're going to remove a bit of a smokescreen that exists under the compensation system by having these, kangaroo court processes as part of the compensation. Strip that right out. That's not what we're here for. We're here to provide benefits to workers, period. And we're going to ring fence that so it cannot be used as a smokescreen for either employers or to combat fraud, which is more alleged than real on the part of workers. And simply say, look,
Kendall,
here's a problem. We're shipping that out to professionals who handle due process.
right. Kendall, the one thing that I wanted to ask you about, which was probably very important for this, is or talk about, is the history of workers' compensation.
Mm,
Is that I have a deep history for some stupid reason. I've studied it, the history. I like history for some reason. I think it's because I'm afraid of being that fool that didn't learn history and is repeating it,
yeah,
as the saying goes.
yeah,
So I know that prior to 1885, and I could be wrong, that workers could sue the employer, but the success rate, according to a paper by an Osgood law professor, I can't remember his name now, it went right out of my head, and he did a research study of case law on it. And the success rate was like about 15% when injured workers were suing employers. So to deal with the question of should we go back to suing our employers, that's a very scary thought.
yeah,
That you've got an 85% failure rate of
yeah,
losing everything. Now,
yeah,
mind you, many injured workers today would say, well, I've got 100% failure now because they're forcing me back to work.
yeah.
So that said, so then in 1885, the Ontario government, and it was the result of 5 workers being killed in a munitions plant in Hamilton, Ontario, there was public outrage, and the legislature passed the Workmen's for Workers, something like Workers for Working for Workers Act. And it
I
really
think that's
wasn't
more
anything.
recent.
Yeah. It had nothing to do with workers' compensation. It was what in Britain they called the Employer Liability Act. It removed those 3 common law defenses, contributory negligence, assumption of risk, and fellow servant.
Well
And
done.
it allowed workers more success
Yeah,
in the courts. But what it did, as Professor Moore of the University of Toronto had written a paper to the legislature in 1900 said, was, well, that's great that there's more workers being successful in the courts. But the rate, according to him, was like 50% or 51%. But remember, you still have 50% or 49% that are still unsuccessful. And these workers are becoming a financial burden to their family, friends, and most importantly, to society, to taxpayers. So then this is what prompted Meredith, or the premier at the time, to appoint Meredith to look into the study, and he spent several years. And what Meredith said, which is something that is often missed, is that he said in his report something to the effect of the true aim of a fair compensation law is to provide for those workers who have been injured or made ill by the workplace so that they and their families don't become a burden to their family, friends, and he says to society, but I specifically state to taxpayers, because I think the thing that's the overarching thing that seems to be missed, especially by, let's be honest, Doug Ford, is that workers' compensation is not taxpayer funded. Yes, businesses pay taxes, but that is not taxpayer. It is nowhere in the law right now, and I think you and Richard would agree, nowhere do I see anywhere the word tax.
yeah,
And it's not on your tax returns or anything. So therefore, and I would say, and I'll go on the record in saying this, Doug Ford's lying when he says it's taxes. It isn't. It is a premium paid
right.
for coverage of workers' compensation when their workers get injured. And the thing that really fascinates me is up until 1990, the Supreme Court had said and recognized in law what they called as the historic trade-off. Injured workers lost, and I like using the word lost because this is the word of the Supreme Court, their right to sue employers. And they say lost because the law took it away. Fine.
Right.
But in its place, to be fair, they gave them the right of compensation. And I
Mhm.
think this is where, like when Richard went to the courts for the gun throw case, the Section 1 thing, this is where the Supreme Court, whenever, or the courts, when you constitutionally challenge that right to sue an employer, was always lost under Section 1 because they would say, well, you have the historic trade-off, you have a right to workers' compensation.
Yeah.
And that's basically the history of it. But today I argue now, which is another thing, is that we've lost that right to workers' compensation now, which can be a renewed legal argument to not to get rid of the whole. See, my goal in making that claim is not that I want to get rid of the system, but I want to scare the crap out of employers and everybody to say, "Oh my God, we could be all sued."
Hmm.
Like
And
the
you're
other
quite
day I heard Glenn, sorry.
Yeah, no, you're quite right because of course that was part of the incentive in getting the
Yeah.
comp system put in 1915 was on the employer's side that increased rate of finding of negligence in the courts was the stick that was beating them to the table. That and the fact that they were, getting a lot of agitation in the workplaces by workers. But that, the big stick, they were losing in, big awards for the day. And now they were getting a lot of those awards peeled back at the appeals court level. But nonetheless, from the reforms that you identified to 1915, it was becoming an increasing problem. And given modern tort law principles and approaches and valuations of claims, if the comp system was done away with in its entirety and it simply went back to negligence, it would be a horrible thing for workers, in my opinion, because of the dice rolling aspect of going into court. And also, you'd only be able to sue for actual negligence, and you'd have to, and the burden would be on the worker to prove negligence um, in a court. But having said that, that would still leave enough scope for claims and the awards coming out of tort law, even in Canada, would be so much higher than the awards coming out of the compensation system that you would pretty quickly have employers once again howling for relief, not just for the expense, but also for the utter uncertainty that that it leaves them in. With a comp system, they know they pay X number of dollars, per year, roughly. They can budget for it and build that into their models of doing business. With a tort system, they never know when something's
Even
going
if,
to
yeah,
hit.
and even if they have insurance, like many people are unwittingly
Yeah,
think, well, businesses can get insurance.
yeah,
And that's what I found fascinating with Glenn Shore from the States. He was talking about the workers' compensation system. That's why I love learning about the different systems. And he was saying, yes, many businesses private insure, and you can do that in Ontario
yep.
through Schedule 2, but there's huge risks to a business for that, which, because if you have insurance, like that's not self-insuring. I mean, if you went to a model like
Total
cars or whatever,
self-insurance.
personal injury,
Yeah,
that insurance only covers you up to so much, right? And then you're on your own.
there's
Richard,
minimums,
you
there's
haven't said anything
maximums.
yet.
And then if there's legal action, there will almost always be legal action if it's large because it's worth the insurance companies and the defendants time to try and cost shift away. There's all the legal
Let,
costs that come
let,
on top of it.
let me ask a political question. The We get calls every week from an injured worker who's lost fingers or something serious, and they're very upset with their non-economic loss award because they get about a 20th of what you'd get in a car accident. So lose a finger, get $2,000 in a car accident, you'd get at least 20.
Yeah.
And I tell them it's a Doug Ford issue, and I give them Doug Ford's phone number. And as if I'm speaking Swahili to
Yeah.
them, when I tell them it's Doug Ford, go give him a call and complain.
Yeah.
Don't take it out on me.
Mhm.
Then there was the Injured Worker Day at Queen's Park on Saturday, and there were about 150 people there. We sent out a notice to about 200 of our clients inviting them to attend. And as far as I know, none of them attended. So I've asked my staff as they speak to them to ask them why they didn't show up, assuming they're not from Thunder Bay or whatever, to try and figure out why they didn't show up. And I guess the question is with the whole Meredith Act policy and lobbying, is it going to cause us to get some more injured worker participation in the political side?
A good question and a very, very important question. And the answer is I don't know. What we can do with this and what we have done with this is by creating an alternative from the bottom up, we are creating a model as well as a very practical exercise in in participatory democracy rather than the very hierarchical, very centralized top-down exercise of political power that we've got right now. And on one hand, I'm very grateful to the NDP caucus for picking this up. But on the other hand, the NDP is just as guilty as the other parties for perpetuating a top-down approach to politics that would be instantly recognizable as a patron-client relationship to an ancient Roman, and is essentially non-democratic. And that's something that has to do with a much, much larger social and political culture issue where we're trapped in this dead end of consumerist patronage politics model, and we've lost the capacity for self-mobilization. Who was it? Putnam, Bowling Alone. The death of social organizations and the accretion, atomization, and isolation of individuals. And I think we see that very much in our particular sphere of workers' compensation. One of the things, of course, that we do, what we're doing with this podcast, is trying to reach out to people and say, "Hey, you're not alone." This is one of the problems that got me into this is the isolation and increasing risk of suicide for my former clients, and almost all of them did think about suicide at one point, which is my motivation for continuing to do this. But this atomization and isolation has to be combated with a practical solution. And I hope the Meredith Act is that solution, as well as just reaching out. Reaching out to no particular point doesn't cut it. Reaching out with an objective in mind hopefully will be more successful. Will it be successful? The battle is not over in October. And once the act is articulated and out there, it can continue to be wielded until it gets passed, including the next election, where you can simply say, will you put this in your first 100 days? Yes or no? And continuing to develop it. And the point is that it gives something for people to actually organize around rather than just the nonsense from all the political parties of, you know, here's our here's our meme, here's our slogan, give me your money, please.
Well, I'd like to thank Kendall for the great presentation today. Obviously, continue the struggle. We'll be continuing the struggle next week in our podcast.
Thank you.
Uh, Goodbye, everyone.
La lucha
Bye, everyone.
continua.
Thanks, Kendall, for coming.
Thank you.